The alternative Digitalk. Real issues, real talk.
Hi Rogers, can I ask you something?
Shoot.
What does corruption mean?
Well, summarily, corruption is abuse of public power for personal gain or for the benefit of a group to which one owes allegiance. For example, when a public office is abused by an official accepting or soliciting a bribe. By the way, private people can be corrupt too, like bribing police officers to escape fines.
Okay. So exactly how does that concern me?
Well, do you pay taxes?
I guess, yeah. What does that have to do with this?
Everything. Because those taxes you pay are supposed to facilitate services you use, like water, electricity, roads construction, medicines in hospitals, name it.
Okay, that is much bigger than I thought. But it can be stopped, right?
Well, yes it can, although it may not be as easy as it sounds. And here is the reason why. Corruption roots are grounded in our country's social, political, economic, bureaucratic traditions and policies.
So, what has kept it going this long? I mean, why don't we stop it?
Well, the main reason why it has been here for so long is because institutions are weak, either as a result of poorly defined ethical standards of public service, weak administrative and financial systems, or ineffective watchdog agencies.
What can we do to stop it?
At a national level, we must focus on strengthening the independence and effectiveness of public institutions that fight corruption. At a personal level, we must commit to never giving a bribe.
I promise I'll never give a bribe.
Well, that's a great decision you have made. Me and you now have to spread this message to all our friends. If we all do our part, corruption will be no more.
This message is brought to you by Alternative Digitalk. The alternative Digitalk. Real issues, real talk.
Good morning, our viewers. You're most welcome to this show, Tekachi, and I'm called Katoto Musime. This show airs live every Tuesday at 11, and we always apologize. I want to extend my apologies whenever we cannot make it here because of unavoidable circumstances. But whenever we get time and we are okay, we shall always appear and have our shows live. This is the Alternative Digitalk, streaming live on our Facebook pages, The Alternative Uganda and Digitalk TV. Later, our shows are uploaded on our YouTube channel, The Alternative Uganda, and you can always follow us, like our pages, share this video to the rest of the people so that they can also learn something new and understand whichever topic we come up with for discussion on different and specific days. Today, we shall be talking about things that are concerned with criminal prosecution. What happens when somebody is brought before court and now it's time for the prosecution side or the state to now begin its case. And then later on, if time allows, we shall also talk about some of the defenses that are available for the accused person in such criminal matters. And in that case, we have heard so many people talk about defenses, mental illness, talk about defenses of insanity, talk about defenses of intoxication, and among the rest, so many. And we shall be tackling them today. But before I can introduce my guest for today, I want to talk about some legal alert. And this is something that has now become a norm for Parliament to sit and pass acts just without quorum, when they very well know that when an act or a law is passed by Parliament and the Parliament lacks quorum, then it's null and void because it contravenes the different articles of the Constitution, that is 88 and 89. And then that's what happened in some case where Parliament passed an anti-narcotic drugs law, and it was nullified for lack of quorum. That's why you saw so many people who are part of the association that grows miraa or cat or whichever you can call it, were jubilating and celebrating. But I want to welcome Counsel Sheya today, who is with us today, for this show to discuss different things that are available today. You're most welcome on this show.
Thank you, Mr. Kato. And I would want to thank this station for having dedicated its time to teaching the ordinary citizens about the law and the justice system in the country. It is really a good idea, and we thank you for dedicating your space and time to teach the public. And I hope the public would listen in, and we also thank them for spending their resources to tune in, listen, and follow the discussion. Thank you.
You're most welcome, and thank you for always giving us time whenever we call upon you to come and appear. It is not easy for most of people in your category to leave their workplaces and maybe leave their clients to come and educate the citizens and the people watching out there. Our show is always live, so if you have any comment relating to what we are discussing today, you can feel free to share that comment. And we shall start from the discussion that we are having today. And remember, the other time we were here, we are talking about the criminal process, how it goes from the time of arrest. Somebody is arrested, taken to police, maybe brought to court for plea-taking. And I want us to start from there, and you'll guide the viewers from that point. When a person, the accused person, takes plea, and you discussed well the pleas that are taken, and I want you to start from that same point and help our viewers to understand.
Thank you so much. As you've rightly put it, the last time we were here, we were talking about the time between the person is arrested, what happens, then the person is brought to court, and briefly to take you through what we talked about last time, we said the criminal case will basically start with a person moving to a police station and making a complaint.
Yes.
The complaint might be in writing or formally written or informed by word of mouth.
Yes.
You move into the police station and talk to the officers, and then the police would open up a general inquiry file to investigate the nature of your complaint now. And if from the investigations the police is of the view that there is an offense that might have been committed, they will now draw what we call a charge sheet.
Yes.
And on the charge sheet, what in the police terms they would call the police form 53, which will have the particulars of the accused person, basically the offense that the person is alleged to have committed, and the particulars, basically
so it will simply state the offense.
The offense and
then the person who is being charged, they are accused of committing that offense.
And the brief facts of that offense, basically. What is it about?
Okay.
You've committed, let's say, you're charged with, let's say, the offense of robbery. What happened? In other words, the police should be able to
state
that. Because, as we say, the police can arrest and prosecute and charge. This accused person also has his right.
His rights, okay.
To be informed of the offense and all that. So the police should always, and of course that is not for the police alone at that stage. You also have the state, the state attorneys, and basically the office of the DPP now.
Yes.
Assisting the police in drawing the charge sheets and guiding on the areas of investigation that they may interest themselves in.
Okay.
So that's what we are doing about, I think, in the last discussion that we had. Okay. So today now, we're going to look at what happens after that.
Yes. What happens in court specifically when somebody, the accused person, is brought?
Because now the person is brought from the police station to court. And that suspect now, because remember, at that stage, the person is still a suspect. Is not yet accused.
Okay.
The person is still
suspected to have committed
an offense. So, this person will be arraigned in court. Of course, that now depends on the area where the offense was committed. In most cases, because we have different courts all over the country.
Yes.
So the court that they will take this person to is preferably the court that has jurisdiction over that area, especially for the offenses that are triable by the magistrate courts, what we may call the non-capital offenses.
Yes.
Because, as we shall see later, jurisdiction is also part of this whole criminal process. So, from that point, the person is brought before the judicial officer. And in this case, we are talking about a magistrate, regardless of the rank of the magistrate, either grade 1 or the chief magistrate. And at that point, the initial stage in this arraignment is that the charges should be read to this person, what we may call now plea taking.
Yes.
Plea taking. When you talk of plea taking, you're saying an answer to the charge.
You're answering to the charge is read to you.
The charge that was.
Court.
Because we say that the police, they will prepare the charge sheet in consultation with the state attorney, and that's the charge that you're going to be brought to court on. So
in simple terms, they will ask you whether you know the facts read to you or you don't know.
The magistrate will read the charges to this now accused person. And the charges should be read to the person in the language that he or she understands best. It's not that they will read, because obviously the charge sheet will be in English as the language of court that we use. But remember, this person may not be conversant with the English language. So, even before reading these charges, the magistrate will ask the accused, which language do you understand best? So that he's aware of these charges that have been brought against him. So that regardless of what happens later, he can be able to answer sufficiently to the charge. Because obviously, if you've not understood the nature of the charge, you may not give a just answer. So that's why it is very, very important that the judicial officer ascertains the language that that person understands. And then now reads the charges, and they are explained to the person in that language that he or she understands. And that is the norm across our criminal law system.
Okay.
That if the person does not understand the English language, then you must have someone to interpret
for them
the nature of the offense. And after the charges, now that the charges have been read and the person has understood the charges, he will now be required to give an answer to the charge.
Okay.
And basically, the accused person can give you either of the three answers. Either that he committed the offense, he has understood the charges, and he agrees with the facts as they have been read and explained to him. And at that point, that is what we call the plea of guilty. The plea of guilty. Or the accused may tell you that I've understood these charges, but I've never committed
Such an offense.
such an offense. I'm hearing it the first time. So in other words, the person is telling you that he never
I am not guilty.
committed the offense, and that is now the plea of
Not guilty.
not guilty. Or the accused person may opt to remain silent.
Okay.
That is also his right. He may choose to remain silent.
And what happens when they are choosing to remain in silence?
Now, when the accused remains silent, the presumption is that he has denied the offense.
Okay.
So the plea of not guilty will also be
Is also entered.
And that means the state now has to prove the case against this person. So those are the three answers that the accused will usually give. But of course, there are other responses that he can give. Either he had already been charged and convicted of the same offense, or he was charged and acquitted of the offense. Same facts.
Some facts.
When you talk of charged and acquitted or convicted, you're talking about the same facts as they are. Because today you may commit, let's say, the offense of aggravated robbery. I don't know how I explain aggravated robbery. In Uganda they say, obubbi ng'okozesa eryanyi.
Yeah, that's the correct one. Like using excessive force.
Excessive force.
While committing that robbery.
So, and you're charged, you're convicted of that offense. Then you serve your sentence, you get out. That means you can never be charged again of that same offense. But if you commit another offense, still of aggravated robbery, you can still be charged and prosecuted. So the public should be aware of such. Doesn't mean that if you have been convicted once, you will never be.
Then you can continue committing the same offense.
No. It would not be that way. Or the person might have been pardoned by the head of state under the prerogative of mercy. What we call, in most cases, presidential pardon. That the person was charged, convicted, and the president pardoned that person. So you can never charge the person again for that same fact. So, and now even at plea taking, we have two instances. There are those offenses that are triable by the magistrate.
Okay.
And there are those offenses that are only triable by the High Court. When you talk of offenses triable by the High Court, you talk of the capital offenses.
So in simple terms, you can explain to the viewers what capital offenses are. What differentiates them from these other offenses? To say this one is a capital offense, this one is not capital in nature.
The capital offenses, you're talking about the offenses that carry a punishment of death. So the difference is now in the punishment. Those offenses that carry a punishment of death, that if the case has been proved against you, then you're likely to suffer death.
Then that's capital.
Those are capital offenses. And those ones can only be tried by the High Court. It's only the High Court that has the power to hear those cases. But given the nature of our criminal justice system, every offense starts from the magistrate's court. If the public has been vigilant about that, every offense starts from the magistrate's court. And for the capital offenses, they start with what we call the committal proceeding. That you have been arrested for a capital offense, but the police is still investigating.
Yes.
And remember, we have said this is only trial by the High Court.
The High Court.
So what happens is that you'll be brought before the magistrate's court.
Okay.
The magistrate will read the charges to the accused. But remember, the magistrate has no, power to hear the case. So in such circumstances, when you say you've been charged with a capital offense, you appear before the magistrate's court for committal proceedings. The magistrate will not require the accused to take plea. No. The magistrate will read the charges and remand the person, the accused.
So this is where they always tell the accused person that don't say anything because the court lacks jurisdiction.
That's where you hear the magistrate saying, you've been further remanded until that date.
Yes.
But you're not required
to answer to the
say
charges.
anything about the charges, because your offense can only be tried by
the High Court.
The High Court. So that means yours is capital.
A capital offense.
Capital offense. So the magistrate is simply fulfilling a statutory obligation. Because some of these laws we inherited them from the colonialists, and they have remained on our statute books for some time.
Yeah.
For example, if you have to look at the Trial on Indictments Act, which is the law that basically governs criminal trials in the High Court. If you look at Section 1 of the Act, for an offense to be brought before the High Court for trial, a person must have been committed by the magistrate. So, and basically the committal proceedings are on ensuring that at least before the person is committed, the police and the DPP have gathered enough evidence that is going to be used at the trial. And by that, the essence, I think, was to reduce the case backlog at the High Court, which I think we can talk about some other day.
Yes.
Because it also causes some delays when it comes to the rights of this accused person. But the whole essence is that if your case is only trial by the High Court, then the magistrate can only remand, read the charges, and if the investigations are complete,
that's when they can commit.
That's when they can commit. If the police informs the state attorney now, or the DPP, that investigations on that matter have been completed, then that's when you move from the charge sheet that you are brought on initially
from
the police to an indictment. The indictment is now for the High Court trial. And then they also give you a copy of the summary of the case. In other words, an explanation as to the nature of this offense. How was it committed? And what evidence will the police and the state now rely on in proving the case against you?
So it is also brought to you, and you have a copy, and you know that this is the kind of evidence that is available against me, or
yes. The copy is given
to you. Mandatory.
It's mandatory. It's mandatory. It's the accused's right to be given a copy of the indictment at committal and the summary of the case. And the purpose of that is for the accused to now prepare his defense. To prepare his defense to the charges. Because now you know what will be relied on at the trial. So in anticipation of that, the accused should be able to prepare sufficiently and respond to that. So that is if the offense is triable by the High Court. But if the offense is triable by the magistrate, meaning those offenses that do not carry the punishment of death. Maybe we should give our viewers examples of offenses that carry punishment of death.
Yes.
We have murder.
We have murder.
We have aggravated robbery.
Yes.
We have offenses like terrorism, treason. Some of
Those are some of the
offenses that are triable by the High Court. And now, if your offense carries any other punishment apart from the punishment of death, either life imprisonment or a custodial sentence, then it means the chief magistrate or the magistrate grade 1 has the power to try the case. But if the offense carries a punishment of life imprisonment, and when we talk of life imprisonment, we mean that if you have been convicted of that offense, you're likely to spend the remainder of your lifetime in prison. Then that offense is only triable by the chief magistrate.
Not magistrate grade 1.
Not magistrate grade 1. At that point, the offense can either be triable by the chief magistrate or it can go to the High Court. So, but below that sentence, all these offenses can be tried by the magistrate grade 1 and the chief magistrate as well. So if the offense is tried by the chief magistrate or the magistrate grade 1, the person has pleaded to the charge. Now, of course, given the nature of our criminal justice system, the day you plead to the charge may not be the day the trial will proceed. You may plead to the charge, but either the police is still investigating, and obviously the investigations have to go on, or even the accused person has not been disclosed to the nature of evidence that will be used against him. So you have, after the plea, the person normally or usually remanded for a given period of time, so that all those processes are complete. The investigations are closed and disclosure is made to the accused. The evidence you're going to use against the accused
person.
So if all those have been complied with, the accused now will still be brought before the judicial officer now for trial. And now we go to, at that point you go to the stage of the prosecution's case.
And now what is exactly involved in the prosecution's case?
Actually, that arises from our constitution. If you look at Articles 120, Article 28, 23, all those will talk about the criminal prosecution. And basically, this criminal prosecution you're talking about, whereas you've committed the offense against an individual or someone, it is deemed to be an offense against the public.
Against the public.
That's why you have
the state.
Yes, you've committed it against the state. That's why you have the state now prosecuting you. And that's why you have all these criminal prosecutions coming in the name of Uganda.
Uganda versus so and so.
Uganda versus so and so, Uganda versus so and so. Yet in your opinion, the accused will tell you, but I killed the other person. I didn't kill the state.
I didn't kill the state.
No. Criminal cases are committed against the public. And now the state has a duty to protect the public. So it prosecutes on behalf of the public. And in all these criminal cases, now that we are the prosecution's case, if the accused has denied committing the offense, it would mean that the state as the prosecutor has the burden to prove that the accused committed the offense. It's up to the state to bring evidence that it is indeed this person that committed the offense. And that's why you say that the burden is always on the prosecution to prove beyond reasonable doubt.
So does that mean that the accused person is not concerned about whatever is happening at that stage? His role is to only listen to the evidence against him or her brought by the state.
Okay, thank you so much for that. At that stage, it doesn't mean that you sit and listen, but as the state is now leading its witnesses,
yes,
your role as the accused person is now to discredit the evidence that is being brought. How? Through what we call cross-examination.
Yes.
You have to cross-examine the witnesses that have been brought by
the prosecution.
Because remember, the prosecution will gather its evidence, but to bring this evidence, it will be through the witnesses.
So somebody that was present when the offense was being committed, somebody that saw what happened.
The person that saw, heard, or is conversant with the facts of that case. So your duty as the accused at that stage is to discredit that person. That the evidence he or she is leading should be disregarded either by the court or should be given little or no weight at all, what we call no evidential value at all. So that's why you have the accused being afforded the chance now to cross-examine those witnesses at that stage. And that is essentially what you will do as the accused. Apart from that, you'll not be allowed to do much unless you're objecting to the nature of evidence or something that relates to the evidence that is being brought before you.
So, thank you so much, Counsel. So our viewers should know that at this point where we say the accused person or their lawyer cross-examines the witness, this is where they normally ask questions that are very hard, and we always see the witnesses shake in the dock. So this is the cross-examination that we are talking about, and its purpose is to discredit the evidence that is brought against the accused person at that point in this trial by the prosecution.
Yes. That is why that is a very, very crucial stage in a criminal prosecution. Because you can either be acquitted based on that, or even convicted based on that. So it's very, very crucial. And that's why we usually encourage the public, if you've been convicted, charged of a criminal offense, at least solicit the services of a lawyer. Because there are those small things a lawyer will pay attention to that a person self-representing will disregard.
Yes.
Because that also has been the challenge. Whereas we say that the person can either be represented by a lawyer or
he can represent
himself or herself, I would be of a view that these people should be encouraged to be represented by lawyers, not necessarily out of self-preservation. Because look, do you want to kick us out of business? So, but obviously there are those aspects the lawyer will pay keen attention to, which might be very crucial to your acquittal or your conviction, which on an ordinary eye you may forego. Because what happens if you have been to if you have seen people that self-represent, for what you may, in the public view, take to be the correct position, actually when you come to the court, it might be the opposite. Because the court of law is a court of evidence. It's a court of evidence. And what most of our people do, because he has his opinion from wherever he has come from, he thinks that is the truth. And most of them end up messing up their own cases at that stage. So it's always very, very crucial to pay attention to the cross-examination and give it your best, either as an advocate or as a person who is self-representing. So that when you come to your own case now as the defense, you have at least discredited
the evidence.
The evidence of the state.
So I want you to also add something on that regard. We have always heard these things, and I hope our viewers may need to understand them. After the prosecution has presented its case, then we normally hear rulings on whether there is a case to answer or no case to answer. So you can highlight it to the viewers.
After the prosecution has laid all its witnesses, you come to what we call closure of the prosecution case. At that point, the prosecution or the state has closed its case. It has literally laid all the evidence that is there to be laid.
Okay.
So, because we said the burden is on the state to prove the guilt of this accused person. Now, after the prosecution case is closed, it is incumbent upon court to evaluate whether, looking at the evidence available, there is a case to answer. What you hear people call the prima facie case. That looking at the evidence that has been so far laid, if this accused person opted to remain silent, then any reasonable tribunal would convict on such evidence. That's what we call the prima facie case. Or what you call case to answer. That looking at this evidence, any reasonable tribunal, any reasonable court would have no conclusion but to convict the accused. And that's why we are emphasizing the aspect of cross-examination. Because remember, a no case to answer can be upheld or can be successfully made under two instances.
Okay.
One, that the evidence available is too weak. It has been strongly discredited under cross-examination. That no court can never convict a person on such
evidence. Even when the accused decides to stay silent.
Yes. That's why we are emphasizing cross-examination. You're saying this evidence has been strongly discredited.
Nobody can believe in the truth.
Nobody can believe in such evidence. Or the second instance is that the state has failed to bring or to lead evidence to prove an essential element of an offense. When we talk of an essential element, for our viewers to understand, for every offense that is there, we have what we call the elements of that offense. In other words, what makes it an offense? Because in the last discussion we had, I think some time back, we are doing about that before you being arrested, this offense should as well be provided for in the law. So, at this stage, you're saying that I was arrested for this offense. And under the law, this is what must be proved for me to be
convicted of such an offense.
Let's take an example of murder. If you're saying the person is being charged of murder, you must prove, one, death of a human being.
That somebody died.
Then, that the death was unlawful.
That whatever caused that death was unlawful.
Yes. Or, and the next one is that the death was still caused with what we call malice aforethought. You had intention.
The bad intention.
You had intention to cause death.
The unlawful death.
And then, lastly, that it is you, the accused, that participated or that caused the death.
So those are the elements you're talking about.
Those are the elements. And for every offense has its own elements that must be proved if the person is to be convicted. So, if you're saying the state has not brought evidence to prove that essential element, then there is no offense. In other words, if one element is lacking, then there is no offense.
So it means the prosecution can prove all the elements. For example, in murder, there is a dead body, the cause of death was unlawful, and that there was malice aforethought. And when it fails to prove the participation of the accused, it means it has failed to prove the elements.
Yes, it has failed to prove the case.
And it means there is no case to answer at that stage.
Yes.
So the viewers can understand that.
Yes.
That each and every element must be proved by the prosecution.
Yes. And going back to the elements, when you're talking about the elements, you're still talking about the act and the mental element of the accused. That there was an act that is prohibited by the law that was committed.
Okay.
And it is the accused that committed that act. And that the accused had the intention to commit that. It's what in law we call the mens rea. So those two must as well be proved. The illegal act or the prohibited act.
And the mental state.
And the mental state of the accused at the point of committing the offense is very, very important if you're to be convicted.
Okay.
So if any of those elements is lacking, then at that stage you can as well successfully plead that the state has not made out a prima facie case. And because we are saying in criminal prosecutions, the burden is on the state, and usually the standard is beyond reasonable doubt. That looking at the evidence, surely the only conclusion the court can make is that of guilt. But here at this stage, the standard is not beyond reasonable doubt. Ask me why.
Why do you think it's...
For one reason. You've not had the accused's case.
Okay.
You've only had one side.
You have relied on the side of the
prosecution. So that's why at that stage, you're looking at this evidence on a standard of slightly above the balance of probabilities, but not beyond reasonable doubt. Because you're yet to hear the
accused
defense now.
Himself.
So that's why at that stage, if now the court is of the view that there is no case to answer, in other words, the evidence is either weak or has been strongly discredited, or that an essential element has not been proved, the accused person will now be acquitted of the offense. Be set free, in other words.
Be set free and told to go home.
He will be let to go and enjoy his life outside.
Even before defending him or herself?
Yes. As long as there is
no case to answer,
the accused will be acquitted of the offense. Unless there are other charges apart from the one that has been acquitted. But usually, that is it. If you say there is no case to answer, the file will be closed, and the person will be let to go. But if they say there is a case to answer, that looking at the evidence, a reasonable court would convict you if you offered no explanation, then that means you go to another stage now, which is the defense.
The defense case.
The defense case. Now the accused person is put on his defense. But before that, at that stage, the accused has his rights as well, as an accused person.
And what are some of those rights at that stage?
If they say there is a case to answer, the accused has 3 rights.
Okay.
1, he can opt to give sworn evidence.
Okay.
In his own defense, he can decide to give sworn evidence, what we call giving evidence on oath.
On oath.
And that means you'll be cross-examined on that.
And that same
evidence on oath. Or this accused may choose to give an unsworn statement or unsworn evidence.
Okay.
You're saying, me, I don't want to give evidence on oath. Don't want to swear.
Because you don't want to be cross-examined.
You don't want to swear that what you're going to say is the truth. Because the oath, by its nature, you're saying that I'm telling the truth and
nothing but
the truth. So a person may choose to evade that route and decide to give plain evidence.
So does it have any effect where somebody gives evidence on oath and evidence, the unsworn evidence? Does it make an effect? Does it have an impact on your case as an accused person?
Yes, it has an impact. Because if you give unsworn evidence, the weight that is usually attached to that unsworn evidence is usually very, very little, as compared to a person who has given evidence on oath. So the difference is now in the evidential value of your statement. If you're saying, I'm giving evidence, not on oath.
Not on oath. It means you have also some doubts that it may be not true.
Not necessarily doubts, but given the nature of, we are all human beings. Someone would be ready to believe someone who has taken oath. Because we all know the effects of an oath. You're swearing, and if you tell a lie, you're committing an offense still.
Another offense. An offense in an offense.
So that usually carries more weight than a person who has just given a plain statement. So, and the third right that the accused has, but before you get the third right, you need to know that the aspect of giving unsworn evidence is only available to the accused.
Not to the witnesses.
Not the witnesses of the accused. It's only for the accused.
These are the rights of the accused, not the witnesses that come on his side. Okay.
So if the accused decides to give unsworn evidence, that is his own right.
Right.
If you decide to call witnesses, then it's a different. The witnesses can only give evidence on
oath.
On oath. Or the last right, or the third one is, this accused person may remain silent. Choose not to say anything. In other words, may choose to.
Even when he's put on defense, he can still stay silent.
Can still remain silent.
Okay.
Still his right. But in all those three, this accused person has an unfettered right to call witnesses to his defense.
Even when he decides to keep silent, he can still call witnesses to give evidence on his side.
Yes.
Okay.
But of course, usually, if a person chooses to remain silent, hardly you will find them called witnesses. The person has totally decided to stay silent on all the proceedings.
So when the accused person stays silent, and maybe he decides not to call the witnesses, what happens now in the prosecution's case?
Of course, now that means the court will evaluate the prosecution evidence.
Okay.
And if it is of the view that it satisfies the essential elements of the offense beyond reasonable doubt, then the person will be convicted. But if applying the standard of beyond reasonable doubt, the court forms the opinion that the evidence cannot prove the elements beyond reasonable doubt, then the person will still be acquitted. Doesn't mean that once you remain silent, you're always going to be convicted. We have one prominent person in this country who opted to keep quiet, and the offense was, the person was acquitted of the offense. So doesn't mean that if you choose to remain silent, you'll be convicted. But before remaining silent, you also need to evaluate the evidence on
by the state.
Because you may choose to remain silent, and
when the evidence
is overwhelming,
the state is overwhelming and can lead you to a conviction.
Yes, so it is always prudent.
Okay.
And as I said, on all those three rights, this person can call witnesses, especially on the first two, giving sworn evidence and unsworn evidence. This person can call witnesses. His defense now.
And he also goes through the same processes of reading the witnesses' evidence, and then cross-examination happens.
Yes.
And then re-examination.
Yes.
Okay. So there is no change. Whatever is done on the state side is also done on the accused side.
Yes, it is usually the case.
Okay.
But now for the accused, you know, the accused has no burden to prove his innocence. For him or for her, the duty is to raise doubt in the prosecution's case. And that's why you are saying that there are some defenses that this person can raise.
As we come to close, because time is not on our side.
Okay, let us briefly maybe go through the defenses.
Go to some defenses.
You have what we call the defense of alibi.
Okay. Well,
alibi, you're saying that you were not at the scene of crime at any one moment. The offense was committed, yes, but you are not
at the crime.
At the scene of crime. In other words, you're saying it is not me who committed the offense. Technically. Because if I was not at the scene, then that means it may be the offense was committed by some other person, not me. So then the other offense you can look at, you have insanity, or what we call now mental illness.
Okay.
But now, mental illness, you're saying the person has been diagnosed with a mental disease at the point of committing the offense. This mental illness is prior to committing the offense, not after you have committed the offense. Because if you can successfully prove that at the point of committing the offense you are suffering from a mental health disorder, then that can be an absolute defense against the charges. Because technically the person is saying that I may have committed the offense, but I didn't have the capacity to distinguish wrong from the right. And actually what happens is, if you successfully plead mental illness, usually you first accept the offense.
And then you plead.
And then now you say, but at that point,
not understanding.
I could not differentiate what is wrong, or if I could understand that it was wrong, but I didn't have the capacity to control the actions
and make a good decision
at that time. And yesterday you have, I think yesterday or the other day, this shooting at Parliament, at the Parliament Avenue. You have the police saying
This person
that
was...
the police officer had previously been diagnosed with a mental illness. And he had been, I think, prohibited from holding a gun. And now at that stage, the police is shooting itself also. Because if you say the person had a mental illness, you have records showing you have stopped this person from holding a gun. Then what are you investigating? Because that is an absolute defense.
If it's proved.
If it can be proved.
It's very absolute, and this person can be set free.
Yes, the person can be set free. Only that, of course, not set free per se, but usually the courts will now...
The punishment will be lesser.
The punishment may not be there, but now you go to institutionalizing this person. What we call taking this person to the mental health
hospital
facilities that are available. They will not just release the person to the public, but they will take the person for rehabilitation and all that. So, if that person is to surely organize his defense well, that is one of the cases that you can easily get away with.
Okay, as we come to the close of the show.
As we come to the close of the show, the other defense you can look at is insanity. We have looked at insanity. Intoxication. But here you're doing about involuntary intoxication. That you did not intend to be intoxicated for the purpose of committing the offense. That you either took a drink or a food that you didn't know was either adulterated with drugs or the food was mixed with drugs. So it was not your own doing to be intoxicated. But if you do it intentionally, then you'll be charged. You'll be charged. So those are some of the defenses
that are available.
That may be available.
Okay. Thank you so much, Counsel, and I will give you just in about 1 or so minutes to give your concluding remarks for today's show.
So I would want to thank our viewers for tuning in and listening in. Hope that we'll be afforded more time on another day to come and conclude the topic, and we surely understand how the criminal process operates. We thank you so much, and we hope to see you soon.
Thank you so much, Counsel, for sharing your time with our viewers and the viewers for watching. We are always here every Tuesday from 11 a.m. And we can't thank you enough for always following us at the Alternative Uganda and Digitalk TV Facebook pages, then later on the YouTube channels. Share the links to the colleagues, share to friends, so that they can also gain something from this very wonderful discussion. I'm Katoto Msime, the host of this show, and I want to thank you and wish you a lovely afternoon, and God bless you.
The Alternative Digitalk. Real issues, real talk.